Afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. We'd like to welcome you to our webinar today entitled Behavior, Discipline, and Students with Disabilities, Special Ed Discipline Requirements. Today I am really pleased to introduce to you Patricia Williams, our presenter. She is the Assistant Director of Special Education on the Special Education team at the Wisconsin Department of Public Instruction. Her focus is primarily in the area of procedural compliance, and she has worked for the department for over 15 years. Ms. Williams holds a law degree from the University of Wisconsin Law School. It is my privilege today to introduce to you Patty Williams. Patty?
Yep, hi. Hello and welcome. So as Bonnie said, today I'm going to be talking about primarily the discipline requirements under the Individuals with Disabilities Education Act, or IDEA. So we're going to cover, I'm going to start with talking about just the requirements relating to addressing the behavioral needs of students with disabilities, and then we're going to get into what's a disciplinary removal, what's a change of placement, what's a manifestation determination, when a student can be placed in what's called an interim alternate educational setting, or an IAES, and then lastly just sort of give you some other resources in addition. Before I address the disciplinary requirements, I always like to point out this following IDEA requirement, and that is if the child's behavior impedes his or her learning or the learning of others, the IEP team must consider the use of positive behavioral interventions and supports to address that behavior. This is sort of the requirement in IDEA that really specifies that when behavior is a need of the student, a disability-related need, it needs to be addressed in the IEP. In August, there was a significant guidance to your colleague letter that was issued by OSEP, and I think this letter really sort of helps interpret and provides further guidance about what is meant about that requirement. What the letter says is that failing to address the behavioral needs of a student can result in both a denial of faith and a denial of placement in the least restrictive environment. So if a child has a disability-related need relating to behavior and it's not addressed in the IEP, that can interfere with that child's ability to access instruction and access curriculum. It also might result in the child being in a more restrictive setting. So really what the letter is saying is that if behavior is a need for that child, it has to be addressed through the IEP. The letter stresses that the consideration of whether a student needs positive behavioral supports and strategies, i.e. that special factor analysis, applies regardless of the student's specific disability and is a consideration for every IEP team. In other words, the child does not have to be identified under the area of emotional behavioral disability to have behavioral needs and to have them addressed in the IEP. The letter goes on to state that incidents of behavior and classroom disruptions, as well as violations of a code of student conduct, may indicate that the student's IEP needs to include appropriate positive behavioral support. This is especially true when there's a pattern. So the letter emphasizes that the behavioral needs of the student must be addressed in the IEP. So if you are seeing behavioral incidents for a particular child, and especially if they're being repeated, then you want to consider whether that child has behavioral needs that are addressed that should be addressed in the IEP, regardless of any disciplinary requirement. The other point that I want to emphasize is that behavioral supports, I think, should be thought of broadly. They can include specially designed instruction, related services, supplementary aids and services, and program modifications or supports for school personnel. So they don't have to be limited to just, for example, supplementary aids and services. If behavior is a need, a disability-related need of the student, specially designed instruction should be considered, a goal should be considered, and then what supports are going to help that student reach that goal. The other thing that OSEP cautions is that merely because a student can be removed for up to 10 cumulative school days, and we're going to talk about this in just a minute, before you have to provide services, it doesn't mean that they're free days. It doesn't mean that you don't have to do anything. What they say is that if you have a child, and even if that child maybe already has some positive supports in the IEP, but you're seeing several disciplinary incidents that might be resulting in some suspensions, you want to then have an IEP team meeting to look at that child's IEP, determine if those supports are being effective, if they're working, and what else might that child need to be able to access instruction and stay in the classroom. So they talk about this sort of notion of free days, these 10 free days, and they say there really isn't anything, there's no such thing as free days. That you should be considering whether or not to have an IEP team meeting. And then the last point that I want to make is that the letter also cites research showing that out-of-school suspensions do not deter misbehavior, and are associated with lower academic performance. The student's more likely to fall behind, become disengaged from school, and to drop out. So I think why I like to start with this and why I like to keep it in the forefront is that the goal really is to keep kids in school, keep them engaged, keep them accessing the curriculum and making progress in the curriculum. So anything that we can do in terms of looking at the IEP and addressing their behavioral needs, we want to do it. And when we're seeing a series of behavioral incidents, then that's the time to go to the IEP, look at what's in the IEP, and see if there needs to be more things added to the IEP. So I just want to mention that. It's a great letter, and I encourage you to look at it before we start talking about the disciplinary requirements. So now I want to talk about sort of the other sort of thing I like to say before we get into the specific IDEA requirements, is that children with disabilities are entitled to the same disciplinary protections that are afforded to children who are not disabled. And that means, for example, that they cannot be disciplined more harshly, and they are entitled to the same due process protections. State law also continues to apply. State law limits suspension of any student to 5 consecutive school days or 15 consecutive school days if an expulsion notice has been sent. Okay, so now I'm going to turn to the discipline requirements under the Individuals with Disabilities Education Act. And there are specific disciplinary requirements for children with disabilities. These are found in federal law. The state law makes reference to them, but the particular requirements are found in federal law. Children with disabilities can be removed for disciplinary reasons for up to 10 cumulative school days in a school year before the special education disciplinary requirements apply. So for example, if a child was suspended for 3 days in October, and then another 3 days in November, and then another 3 days in December, so those are 9 days, they wouldn't apply. But then if they're suspended for 2 more days in January, that 11th day, they would start applying because it's been more than 10 days. So it's a cumulative. So after the 10th cumulative day, the disciplinary requirements kick in. But remember, as OSEP said, there's no such thing as free days. So when you're seeing those suspensions kind of piling up, I strongly urge you to have an IEP team meeting to look at the supports in the IEP. Services are required during the first 10 days of removal in a school year only to the extent services are provided to children who are not disabled. So if you do provide services to your students who are not disabled in the school setting, then you have to provide those services to children with disabilities as well. But if you don't, then those first 10 days you don't have to provide services. Services must be provided beginning on the 11th cumulative day of removal during a school year and then during any subsequent removal. The services, and this is really important to keep in mind, must enable the child to continue to participate in the general curriculum. Okay, so they have to continue to participate in the general curriculum, although it can be in another setting, and then to make progress towards meeting the IEP goals. So it's both. They have to be able to make progress towards meeting their IEP goals, and they have to be able to continue to participate in the general education curriculum. Now, the comments to the regulations state that this does not mean that the school district must provide every aspect of the services that the child would receive in his or her normal classroom. Services may also vary depending on the needs of the child and the length of the removal. The comments state that a child is removed for a short period of time and who is performing at grade level may not need the same kind and amount of service as a child who is removed for a longer period of time or is not performing at grade level. So it's a case-by-case determination as to what services the child needs. And as long as the removal does not constitute a change in placement, the decision about what services are required is made by school personnel, the principal, or another administrator in consultation with at least one of the child's teachers. So if we're not talking about a change of placement, then in determining services, it's made by a principal or another administrator and a teacher, and it's to look at a case-by-case sort of what does that child need given the length of removal and where they're at in terms of their academic performance in order to sort of determine what that child needs. So now I'm going to talk about what do we mean when we're talking about counting removal. Okay, so what is meant by a school day, first of all? School day means any day, including partial days, that students are in attendance at school for instructional purposes. So remember, a child can be removed for up to 10 school days, and then the services kick in. So that's why it's important to know what a school day is. In terms of removals, what counts as a removal, part day removals may be counted as part day if that is how attendance is tracked. So if a child suspended for half a day, goes home at noon for the rest of the day, and that's how you keep track of attendance, then that would count as a half-day removal. Out-of-school suspensions are always counted toward the 10 days. So that if you suspend a child for 2 out-of-school days, so both those days are going to be counted as 2 days of removal. In-school suspensions are counted toward the 10 days unless the student has the opportunity to participate in the general education curriculum, receive the services specified in the student's IEP, and participates with non-disabled peers to the extent they would have in the current placement. Okay, so what does that mean? So if a child receives an in-school suspension and they're in the regular education environment, that's where they receive their services during the day, and they receive that in-school suspension in a detention room that has regular education students and this student, it's the regular ed environment, and during that day the child's receiving what they need to continue to participate in the general education curriculum. So there's homework and there's some, sort of this is what we learned today in this class and giving them that kind of information, and they're receiving any services that would be required in the IEP, then that would not count as removal. But if those 3 things aren't met and all 3 things have to be met, then it would count as removal. Bus suspensions are counted as removal if transportation is part of the student's IEP as a related service, unless the district provides transportation in some other way. So if transportation is in the child's IEP, they're suspended from the bus, and the district doesn't provide an alternate way of getting to school, they're counted as removals. And that's found in an OSEP letter that clarifies that. The last is called removals that are de facto suspensions. So the removals that may not be called suspensions, but they're essentially suspensions, and they have to be counted as removals. So sometimes a student is sent home because of a violation of a code of conduct, but it's not called a suspension. So for example, if a student's engaged in a physical altercation after lunch and was sent home to cool down, this would still be counted as a removal. Situations where the student is removed from their educational environment because of a disciplinary code of infraction must be counted as a removal. So even if you don't say it's a suspension, the child sent home for an infraction, it's a removal, and it has to be counted towards those 10 days. Now, a question that comes up is, what if it's in the IEP that a student may be sent home under certain circumstances, and those circumstances are specified? First, I just want to caution on this. This should be extremely rare, and if it is, it has to be based on the individual needs of students. So it can't be just a way of sending the kids home, but it has to be because of the individual needs of the student. But if it's in the IEP and the IEP is implemented, then this wouldn't be considered a removal. However, the caution is if this student is sent home on a frequent basis, or it becomes a frequent basis, then that can be a FAPE issue, because then the child's not receiving instruction. So they're at home and not receiving the services that they're entitled to under their IEP. So again, this should be an extremely rare situation, and it should be based on the disability needs of the child in determining whether or not there's circumstances where they would need to be sent home. Okay, so now I'm going to talk about what happens when there's a disciplinary change of placement. Several requirements in the IDEA are triggered when the disciplinary removals result in a change of placement. A change of placement occurs if the removal is for more than 10 consecutive school days. Okay, and so in Wisconsin, that would be for an expulsion. So if the child was suspended for more than 10 consecutive school days, under Wisconsin law, you'd have to send a notice of expulsion, and they would be up for expulsion. So that would be one instance where there's a disciplinary change of placement. The other is that the student has been subjected to a series of removals that constitute a pattern. And so when you think of this from sort of a kind of the purpose or the underpinning of this, what this really means is that if a child's being frequently removed from their placement, it starts to become that, again, sort of de facto, or in essence, the child has a change of placement. There's a disciplinary change of placement because it's happening so frequently. There's this pattern. So the two ways that are defined under IDEA where there's a disciplinary change of placement, if it's more than 10 consecutive school days, it's going to be an expulsion in Wisconsin, or there's these pattern of removals, a child just being taken out so much that it just, in essence, becomes a change of placement. So how do you know if there's a pattern? What does that mean? Well, the IDEA sort of outlines sort of the factors to consider. One is that the series of removals have totaled more than that 10 cumulative school days. Okay, so I'm talking about that, 3-day suspension, another 3-day suspension, another 3-day suspension, that cumulative. The student's behavior is substantially similar to behavior in previous incidents that result in a series of removals. And then also to look at such factors as sort of the length of each removal, the total amount of time the student has been removed, and the proximity of the removals to one another. And when I look at sort of how courts have considered this, one thing that I noticed is that they really do look at the total amount of time the student is out. Like, that's a factor that really courts pay attention to. So if the student's out a significant amount of time throughout the school year, they're going to see, more likely to see that as a disciplinary change of placement. And then when looking at, in determining if there's a pattern, you want to look at the number of removals, how close they are together, and are they for similar types of behavior. For example, in one due process case I looked at, the hearing officer found that it was not a pattern when there were 14.6 days of suspension over a 7-month period. So you notice that it's over a long periods of time, and it's a few days over those 10 days. The suspensions were not close to one another, and the suspensions were for different reasons. One was for insubordination, another one was for leaving school, and the other one was for physical aggression. So those are sort of the factors, and that's sort of how courts will look at it. They sort of look at all the things together to see if there's really, in essence, a change of placement. So the decision whether the series of removals constitute a pattern is made by the school district on a case-by-case basis. So the district looks at it, and they determine if there's a change in placement based on a pattern on a case-by-case basis. This determination may be reviewed, though, through due process proceedings. So if there's a disagreement, it can be reviewed through a due process proceeding. And if there is a change of placement, the parents must be notified of the decision and provided a safeguards notice. And then the other thing is that if there is a change of placement, services are going to be determined by the IEP team and not by the administrator and a teacher. So it moves to the IEP team determination. And then, and this is probably the one that most people hear of, is if there's a disciplinary change of placement, a manifestation determination is required. So that is required. The intent behind a manifestation determination is that a student should not be punished for conduct that was caused by his or her disability. However, if the conduct is not a manifestation of the student's disability, then a student with a disability may be subjected to a long-term removal to the same extent as non-disabled students. So if there's a manifestation determination and they determine that it's not a manifestation of the student's disability, then that student can be expelled and they can pursue the expulsion proceedings, for example. If it is a manifestation of the child's disability, then the school district could not move forward with an expulsion. And then the other thing always to remember, and I get to this later, but even if they are able to move forward to an expulsion and the child is ultimately expelled, under IDEA, a child with a disability is still entitled to services. And those services must enable the child to make progress in the general education curriculum and make progress towards the IEP goal. So even if ultimately it results in expulsion, they're still entitled to services. Okay. So manifestation determinations must be made within 10 school days after the date on which a decision to change the child's placement is made because of a violation of a code of student conduct. So they have to be made within these 10 school days after the decision to change the child's placement is made. So who makes the manifestation determination? Federal law requires the parent, the public agency, and relevant members of the IEP team make this determination. However, I can say that in Wisconsin, it is almost always the IEP team that meets and makes this determination. And to me, this really makes sense because there are certain follow-up things you might have to do, and if the IEP team is already constituted and already there, then they can just go ahead and do that, and you don't have to schedule an IEP team meeting. So in making the determination, the members of the group or the IEP team must review all relevant information in the student's file. This would include the student's IEP, teacher observations, and any relevant information provided by the parents. And the comments to the federal regulations state that this list is not exhaustive. The group or the IEP team must also consider information provided by the parents, which might include medical information and diagnosis. I know we've had a couple of IDEA or special education complaints around manifestation determinations, and in I think at least one of those complaints, the issue was that the parent wanted to provide some additional information and it wasn't considered, and so we said that it should have been considered at the manifestation determination. So you want to make sure that the list isn't, it's not exhaustive, and you really want to consider all the information that's made available in determining whether or not the behavior was a manifestation of the child's disability. So in determining whether it is a manifestation, the IDEA provides two parts, and if either part applies, then it would be a manifestation of the child's disability. So the first is the conduct must be determined to be a manifestation of the child's disability if the conduct had a direct relationship to the child's disability, or the conduct was the direct result of the student's district's failure to implement the IEP. So either the conduct was caused by or had a direct and substantial relationship to the child's disability, that's the one way you can show it, or the conduct was the direct result of the agency's failure to implement the IEP. So either or, it's not an and, it's either or, and then it would be a manifestation of the child's disability. For example, and I can give you an example, if as a part of the disability the student had difficulty with impulse control, the IEP team may consider whether the incident involved an impulsive action or whether the actions demonstrated planning and forethought. So that might be something that the IEP team would consider in looking at that first prong and determining whether that is made. The other thing to keep in mind is that this decision is made on a case-by-case basis. And if it's determined that the conduct was because of a failure to implement the IEP, then the district must take immediate steps to remedy that problem. So if it's a failure to implement, then you want to make sure that that part is implemented as they continue on. Okay, so then this happens if the behavior is determined to be a manifestation of the child's disability. So if that applies, then the child must be returned to the placement from which the child was removed. So that's what I was talking about. If there's an expulsion on being considered, but they go to a manifestation determination, it determines that yes, the conduct was a manifestation of the child's disability, then the district cannot move forward with those expulsion proceedings. So the child has to be returned to the placement from which the child was removed, except, and I will tell you that there's always exceptions in special education law, except if the parent and the district agree to a change of placement in the context of an IEP meeting. So they're having that meeting and they decide, you know, this really isn't the best placement for my child, or the district says, you know, let's consider a different placement. And there's an agreement between the parent and the district that the child's going to be in a different placement, then that would be okay. Or if the student is disciplined for behavior involving weapons, drugs, or serious bodily harm. And we're going to talk about that in a minute. So bottom line is that if the behavior is a manifestation of the child's disability, they have to be returned to the placement from which the child was removed, unless the parent and the district agree otherwise, or if it involves weapons, drugs, or serious bodily harm. The other thing that has to be done is that if it's a manifestation, then an FBA has not been conducted, or a functional behavioral assessment, then that has to be conducted, and a behavioral intervention plan must be developed. So if it's a manifestation, the child has not had a functional behavioral assessment, and there's not a BIP, then you want to make sure that that's conducted and that there's a behavioral intervention plan in place. And then if a behavioral intervention plan has already been developed, then the IEP team has to review that and modify it as necessary to address the behavior. So that again is that sort of purpose in, okay, so this child has behavioral needs, let's go back, let's look to see kind of what supports can be provided, how we can revise the IEP if there's already been a behavioral intervention plan to sort of address these needs, maybe the supports haven't been effective. Or if it hasn't been addressed, let's do a functional behavioral assessment and develop a behavioral intervention plan. That's really the purpose behind those requirements. So if the behavior is determined not to be a manifestation of the child's disability, then the school district may remove the child to the same extent it would remove a child who does not have a disability. So they could proceed, for example, to expulsion. And this is what I mentioned before. Services, however, must be provided, and they must be determined by the IEP team. So here, the IEP team would meet. They would determine what services are needed during that period of expulsion. And the services must enable the child to continue to participate in the general education curriculum, although it would be in another setting. and to progress toward meeting the goals set out in the child's IEP. So the IEP team should really be thinking about what services are going to be needed to allow this child to continue to participate and make progress in the general education curriculum and to make progress towards meeting their goals. So the district is still, and this is in IDEA, the district is still responsible for providing FAPE to the student, even if the student has been expelled. Okay, so remember I mentioned that even if it is a manifestation of the child's disability, if it's involving weapons, drugs, or serious bodily injury, they don't have to be returned to their placement from which they were removed. So IDEA says that if it's for any of those offenses, then a child can be placed in an IAES or an interim alternate education setting for up to 45 school days. Okay, the IAES is determined by the IEP team, and again, it's only for these 3 exceptions. The placement may not exceed 45 school days unless it's extended through other means, such an extension granted by a hearing officer, or the parent and the district agree that a different placement is more appropriate. And again, the services, while the student is in this AIES, must be determined by the IEP team, and it must, always those 2 prongs, allow the child to continue to participate in the general education curriculum and to make progress towards their IEP goals. There are just definitions, and actually IDEA refers to definitions found elsewhere in the United States Code, but they're sort of incorporated into IDEA. So they define weapon as a device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except that the term does not include a pocket knife with a blade of less than 2 1/2 inches in length. It's very specific. So in cases that I looked at, for example, metal awls used in leatherworking, sharp adult-sized scissors have been identified as weapons under this definition, so it doesn't have to be sort of what you would typically think of as a weapon. Whereas children's scissors with dull blades, paper clips, and pencils have not been considered weapons because they are not readily capable, at least found by the court, of causing death or serious bodily injury. So, this is the definition in determining whether the behavioral incident involved this weapon. This is what you'd want to look at in determining that. And at this point, if you're a district, you may want to bring in your legal counsel to sort of review this and determine whether or not it would be appropriate to put the child in an interim setting. So illegal drug is another reason for this exception, and that's defined as a controlled substance unless the controlled substance is legally possessed and used pursuant to a prescription. For example, Ritalin is a controlled substance, but it's not a legal drug if it's possessed or used pursuant to a prescription. Ritalin would be an illegal drug if it's possessed or used without a prescription. And then this term also includes what's commonly thought of as a legal street drug, such as marijuana, cocaine, methadone, heroin, etc. Alcohol, tobacco, and over-the-counter medications are not considered illegal drugs or controlled substances under this definition. Again, it's very specific as to what constitutes a drug that would have this exception apply. Okay, and then serious bodily injury is defined as bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss of impairment of the function of bodily member, organ, or mental faculty. When I looked at cases, and there's probably more cases talking about what constitutes a serious bodily injury, and I guess that makes sense because that's where you might have the most kind of doubt as to whether or not it was. Hearing officers often look at pain, so they're looking to see how much pain there was. Did the person that received the injury, go to the doctor? Do they require some follow-up medical care? Do they require pain medication? That's kind of what they're looking at. They often require a high threshold to be met in determining the injury to be serious. So they're looking at really a serious injury. The injury has to be more than a cut, limited pain, brief dizziness, or a bruise. And this is all coming from court cases. A broken nose, a sprain, and a swollen knee have not been considered serious bodily injuries. And then, as I said, factors hearing officers or courts look at include the amount and degree of medical care and whether pain medication is required, and then also the inability to go to school or the inability to work if it's a staff member. That's kind of what they're looking at. So those are the exceptions then. So why they're important is that even if the conduct is a manifestation of the child's disability, a child can be placed in an alternate setting for up to 45 school days if it involves serious bodily injury, a drug, or a weapon. Okay, so if a parent disagrees with the manifestation determination, then the parent may use any of the 3 dispute resolution options available under special education law. So a parent could request mediation through the Wisconsin Special Education Mediation System. And remember, mediation is free to both parties, and both parties must agree to the mediation. The parent may also pursue due process. And if a due process hearing is requested, because it involves a disciplinary matter, the hearing process must be expedited. So in IDEA, there is shorter time requirements for a hearing that relates to a disciplinary matter. The resolution meeting must be held within 7 calendar days of receiving the request. The hearing must be conducted within 20 school days, and the decision must be issued within 10 school days following the hearing. The student remains in the setting to which he or she was removed until the hearing is completed or the disciplinary action expires, whichever occurs first. So what that means is, let's say you have a situation where a child has been expelled, they had a manifestation determination, they determined that it was not a manifestation of the child's disability, so then the child was expelled. The parent disagrees with that determination and requests a due process hearing. The child would be in the expelled setting while the due process hearing is going through. But again, it's an expedited process. And then lastly, the parent may also file an IDEA complaint with the Department of Public Instruction. And the department then will investigate the complaint and issue a decision within 60 days of filing the complaint. And as I mentioned, we sometimes get complaints involving manifestation determinations, for example. Okay. So the last thing I want to talk about is the deemed to know provisions. And that has to do with, even if a child has not been identified as a student with disability, the disciplinary protections still apply under limited circumstances. They apply if the parent, prior to the incident that caused the disciplinary action, expressed concern in writing to the teacher or an administrator that the student needed special education. And I just want to point out that these are very specific. So these deemed to know provisions only apply under these circumstances. So if the parent had expressed in writing that the student needed special education, or if the parent made a special education referral, and again that have to be prior to the incident, or if the teacher or other district staff expressed specific concerns about a pattern of behavior directly to the director of special education or other supervisory personnel, such as a principal. But again, it has to be prior to the incident. So the teacher expressed specific concerns about a pattern of behavior directly to the special ed director or another supervisor prior to the incident. So those would be the 3 ways. So the parent in writing expressed concerns that the student needed special education, the parent made a referral, or there was concerns expressed by the teacher. IDEA is very clear. The district does not have knowledge and the protections do not apply if the parent of the child has not provided consent for an evaluation or refused services. So if in a district, let's say there was a process for an evaluation prior to the incident, but the parent did not provide consent to do the evaluation, or there was a determination made that the child was eligible, but the parent refused to provide consent for the initial provision of services, then the deemed to know provisions would not apply. If the parent revoked consent for special ed, so let's say the student was receiving services prior to the incident, but the parent revoked consent, then it would not be a deemed to know situation and the special education disciplinary protections would not apply. Or in the last case, if the child was previously evaluated and the IEP team determined that the student was not a student with a disability. So they're very specific about when the deemed to know provisions apply and when they do not. And I just wanted to mention that there are situations where, let's say a child, the deemed to know provisions don't apply. The child engages in an incident and then the district moves to an expulsion, the child is expelled, but then after the incident, a request for an evaluation is made. Under those circumstances, the district has to expedite the evaluation, so they want to do that as soon as possible to determine if that child is a child with a disability. And if the child is a child with a disability and the district has to provide services, again, develop an IEP, provide services so to allow that child to make progress in the general education curriculum and to work and make progress towards their IEP goals. So those situations involve referrals made after the incident. The important thing to keep in mind is that you want to expedite the evaluation, and if the child is determined to be eligible, then you want to develop the IEP and provide services. So that's kind of the last piece. But that's all I have for today. So the last slide just is some resources that we've developed as a department. The one thing I was wondering, if you're looking for DPI resources, the best place to go is our index. We have it alphabetical. Any subject matter, you just click on it and it will bring up the resources. We have 3 bulletins that address behavior or the special education disciplinary requirement. The first bulletin is 1602. Those are the legal requirements relating to disciplinary children with disabilities. That bulletin was developed after IDEA was reauthorized in 2004, and then the regulations came out in 2006. So there were changes in the disciplinary requirements then, and so the bulletin was developed in response to that to sort of clarify what the new regulations are. But now they've been in effect for a pretty long time. Bulletin 0701 has to do more about addressing the behavioral needs of students with disabilities. So that talks about, developing those supports and goals and doing a functional behavioral assessment to really figure out sort of what is the function of the child's behavior, so you can address those more effectively with supports in the IEP. The last bulletin that was done more recently is 14-02. That is our bulletin on manifestation determinations, and that sort of walks you through in more detail than I did today about, what are the considerations of whether or not the incident is a manifestation of the child's disability, so sort of that consideration, and then sort of what are the exceptions around the drugs, weapon, and serious bodily injury if it is a manifestation, but the child still is being placed in an entrance setting. So that gets into more detail in that. So those are resources I just wanted to highlight. So now I can take any questions if there are any for the last 2 minutes.
Yes, I do have one for you, Patty, and this has been waiting for a little while. It says, does disability mean diagnosed disability or disability category under which the child qualified for special education?
So that's a great question. So when I'm talking about a child with a disability in context of IDEA, I'm talking about a child that was evaluated under IDEA and found eligible. So that means that they met the criteria for an area of impairment, and they also, the IEP team also determined that there was a need for special education. So when I'm talking with children with disabilities, and I'm really talking about IDEA, then I'm talking about a child that's eligible under IDEA. When we're talking about the manifestation determination, sort of whether or not the incident is a manifestation of the child's disability, and you know, I'm looking at like some case law and sort of saying this and some things, but sometimes, for example, there was a due process decision that was done in Wisconsin, and I think this kind of highlights it. And in that, I think, and I'm relying on my memory, so if I'm not exactly right, I can get to the essence, but I might not be exactly right. But if I'm remembering it, the child, I think, was found eligible under deaf and hard of hearing. I think that was the eligibility criteria. But there was also evidence that the child had ADHD, and there was a lot of contention at the meeting as to really whether or not the child had ADHD. The parents brought in some evidence, but it wasn't clear that it was known to the school district. But there was the argument that the child had ADHD, and so that there was this impulsivity component that the child had. And the hearing officer said, okay, you know, in terms of this incident, and it was the incident involved selling, it was selling look-alike drugs, I think it was. So it wasn't, I think it was marijuana, but it wasn't marijuana, but it looked like marijuana. So, you know, whatever was being sold, it wasn't a drug, but it looked like it. What the hearing officer said is that, okay, so under this hard of, you know, deaf and hard of hearing, there's no connection to selling this look-alike drug. But let's consider whether, even if there's some dispute over whether or not the child has ADHD, let's look at impulsivity as well. And I see most hearing officers doing that. It's like, you know, we're going to take all the evidence and we're really going to look to see kind of if there's something about this child beyond just the area of impairment that is a manifestation of the child's disability. So then they looked at impulsivity, and the hearing officer said, even if we look at this factor, it's not a factor here, because the look-alike drug selling was a very planned activity, that there was planning involved. There was, the hearing officer didn't find anything impulsive about it. So ultimately they said it wasn't a manifestation of the child's disability, but the hearing officer did consider kind of a broader view. So I don't know if that helps your question or helps answer it, but I have seen situations where it goes beyond sort of just the area of impairment and looking at the manifestation. But that's always kind of, it's not clear-cut, but I certainly have seen cases where they've done that.
Yeah, and the comment then followed was that it was speaking, you know, and asking in regard to the MDR.
Okay, so I think that answers it then.
Yeah, yeah. And at this time, I don't have any other questions. Let's just take a minute to see if anybody else has one for Patty in the next couple of minutes. But at this time, I would definitely like to thank you, Patty, for a wonderful presentation today, and like to thank everybody for participating. I don't see any other questions this time. Oh, actually, we do. We just got one, so hang on 1 minute. And
okay.
Let's see. It says, can a school force a child to report to an EBD room every day or for the day because they used inappropriate language? This child does use inappropriate language or dialogue daily. So is it going to be sent to the EBD room daily? Have to, I think the gist is, does the, you know, if the parents are not agreeing and this is what they keep doing, and what happens if it's not in the IEP?
So I think this is an excellent example of when you'd want to have an IEP team meeting to look at what supports are in place for that child, because, as I said, the goal is to keep that child in the, the access to the regular education curriculum, the regular education environment, if that's what's been determined by the IEP team. And so if you're seeing this frequent, removal to a different setting, and I don't know, I don't have the IEP, obviously can't see what's in there, but that's the time where you're going to want to have an IEP team meeting to really talk about what our support's in for that student, maybe some work around some goals, so that that can be addressed and the student can stay in that regular ed environment.
Okay, and I do have some follow-up. One was that in that same question that the school had tried to place the child in EBD, but the parents were not in agreement with that and perceived that the goal is to try and get the kid to attend school all day in regular education. So I think that's just a follow-up to that question.
Sure. So in terms of determining placement, under IDEA, the presumption is that the child's going to be, and it's the least restrictive environment, is going to be educated with their non-disabled peers to the maximum extent appropriate. So the IEP team should be looking at what supports can be in place to allow that child to participate in the regular education environment. When there is a disagreement over placement, so when there's not an agreement by the parent and the IEP team, what IDEA says through comments is that it's a district's ultimate responsibility to determine what that placement is. So if, take your example, if the district determines that the appropriate placement, even considering least restrictive environment, may be a special education environment for at least part of the time, they can go ahead and make that placement through the IEP team, even if a parent disagrees. But then the parent has the dispute resolution option, so the parent could go to mediation, could file an IDEA complaint, or file due process, and that's what IDEA says in terms of the comments, kind of how to handle that.
And we do have one other question that just came in. Can an FBA be done at any time? And it goes on to say, before disciplinary measures are taken, like sent home from school, etc. Say a child is continually kicking others but hasn't had a any disciplinary repercussions.
Yes, absolutely. I think personally that functional behavioral assessments are very helpful in sort of understanding sort of what the purpose and function of the child's behavior is. And so that's something that you could request, that a functional behavioral assessment be conducted, and there's nothing that prevents that being done prior to disciplinary action. So, yep.
And then as a follow-up to the question before, as far as goal setting and the one where the parents and the school wasn't agreeing, the statement was that there appears to be no academic goals, although the parents have asked for them. So, under these circumstances, would there be a way that you can provide some contact information for some of these cases that people would like to further discuss, Patty?
Sure. So what I would do is I can give you the number for the special education team, which is 608-266-1781. And we have, in addition to myself, and feel free to ask for me, but there's several people on our team that work on the area of compliance and could help provide those resources to you. Yeah.
Okay, great. Well, seeing no other questions, again, I would like to take this opportunity to thank Patty today for a wonderful presentation. I felt that I know that I always learn a lot, and I'm sure that everybody who participated today did the same. Thank you, everybody, for your participation. This concludes our webinar for today. We'd like to thank you again for joining us. Wisconsin Facets has over 100 scheduled trainings and webinars for 2017. Please feel free to check our website calendar and register for any of our upcoming trainings. And please watch for the short evaluation that will be coming your way. Thank you, everybody, and thank you again, Patty. Everybody have a wonderful day.
Thanks.